Ladies and gentlemen, this is Bruce from Oregon, Bruce the Moose on the loose, in the tech van from Oregon. We have some breaking news in the state of Arizona versus Laura Owens criminal court case. Thanks to the Justice for Clayton subreddit, we have these nice documents. Let's go through them. These are publicly available court documents. I'm just a human-shaped moose. I make no claims about any sort of mystical knowledge, any sort of elite specializations, any sort of capabilities other than I have a laptop, a microphone, and a van in which to record. So we're going to go through this document and see what we can learn today. This is effectively the witness list for the prosecution in the case, Arizona versus Owens. Let's go through it right now. Attorney for plaintiff in the Superior Court of the state of Arizona and for the county of Maricopa. We have the state of Arizona as the plaintiff versus Laura Michelle Owens defendant. This is the state's notice of disclosure and request for disclosure. All right. We have Judge Garfinkel. That's very good. The state of Arizona, by and through undersigned counsel, hereby give notice of disclosure pursuant to Rule 15.1 Arizona Rules of Criminal Procedure and request disclosure pursuant to Rule 15.2. If this case involves a victim, the state has made every attempt to comply with ARS 134434 and Rule 19 of the Rules of Criminal Procedure by redacting the victim's identifying and locating information. Very good. So we have a redacted document. That's going to be important. If for any reason victim identifying or locating information has been inadvertently disclosed, the state requests that defense counsel immediately notify the state so that it may substitute the disclosure with a copy that conforms to the requirements. Okay, that's fine. The state further requests that any copies of documents containing victim identifying or locating information not be further disseminated to anyone, including the defendant. Okay, very good. Now, Rule 15.1 subset B. Witnesses. Here we go, guys. You ready to go through the witness list for the prosecution? The state may call the following witnesses in the case in chief or as rebuttal witnesses. Okay. First witness, we have a Julie. We'll see who that is. Redacted. Second, we have witness Deandra Arena. That is one of Clayton's lawyers. I wonder if Julie is Judge Mata. We don't know. Or it could be a different Julie. All right. Witness, Jan Black Owens. Okay, that's Laura's mother. So they're going to be calling her. We have various police officers. Officer Blasco, Officer Bowe, Officer Buckner. Witness, Joe Cotchett. Now, this is very interesting. So if we remember some of the earlier cases in this saga, this is Joe Cotchett, or Uncle Joe, as he was referred to in some of the emails. We will see where he comes into the picture in terms of the Owens v. Eckerd paternity case. I thought he was more a player in the Gillespie case, so we may be getting into things related to that. That's going to be interesting to see. Okay, let's go to the next page. We have another police officer, Officer Crown. We have a witness. It looks like Elisa Redacted. Okay, that's very good. Witness, Samantha Deans. Now, this is Dr. Deans, which was Clayton's expert witness at the paternity case. So Dr. Deans testified about the medical information and the operation of Planned Parenthood and all of that. So that'll be interesting. We have Clayton Eckerd himself. Of course, he's listed as the primary victim to these 7 felony indictments that are on the table. Another witness, let's see. So we have, is this Dorabelle? It's redacted. I don't know who that could be. We have a couple redacted witnesses. We've got a Jeannie and a John. Okay, that's fine. And then we've got Detective Fulp. Okay. We have, witness victim protected address, Greg Gillespie. Very good. We have witness David Gingrich. I think they mean David Gingras. Maybe they made a typo there. We'll have to get a little amendment to get his name spelled right. So David S. Gingras Esquire can be properly documented here in the witness list. All right, so we have Officer Gomez, And then we're on to the next page. We have more officers. Now remember, when they did their search warrant for this criminal investigation, they had about a dozen officers assisting with securing the location, securing the property, and helping with the collection of evidence. So they're probably just listing all of the officers that were around or that were part of the briefing or were part of the search warrant execution back in January 25. Okay. Officer Gonzalez, we have Deputy Goodson. Very good. Now we have some redacted witnesses. We've got a Dustin, a Heather, and a Doug. Okay, I'm not sure who these folks might be. These are interesting. Let's see. Witness Jeff Higley. Oh, Dr. Higley. This could be interesting. As we recall, in the cases that weren't the main paternity case, the order of protection and injunction against harassment cases, we saw Miss Owens claim to have seen or have doctors for her pregnancy, Higley and McCool. And one of those she claimed she had seen last Friday. And then, of course, on June 10th, at the evidentiary hearing, the final hearing, she canceled the appointment. So she changed her story there, which is part of the trouble with this case. Can't get the story straight. We have another redacted witness. Looks like Roseanne or Rosanna. We have another witness, Jones, MD. That's interesting. We have Officer Krim, Officer Lebowski here, or Lekowski? Lekowski. No big Lebowski here. Witness, Tamara Lister. That's interesting. I think Tamara Lister was one of the people for the blood HCG test, or another one of these, MomDoc or places where Miss Owens got some medical results. I think Tamara Lister was noted in the June 10th hearing as being the person who may have verbally told her about a February due date, February 14th, Valentine's Day. So we'll see what Miss Lister has to say about that. Okay, let's keep going. We've got witness McCool. So there we go. We've got Dr. McCool. That'll be interesting. Witness Mike Maricini. Very good. Okay, so we have our trio of gentlemen, Mike Maricini, Greg Gillespie, and Clayton Eckerd, witnesses for the prosecution. We've got a couple redacted witnesses, a Robert and a Hunter. That's fine. We have, let's see, witness Michael Medchill. Oh, Dr. Medchill. Now, this was Miss Owens' expert medical witness at the June 10th hearing. And I think he's an interesting guy because he seems to have just given Miss Owens the benefit of the doubt when it comes to her claims of being pregnant. So blood and urine HCG tests alone were the majority of her evidence, as well as some sort of personal testifying about, who she'd been intimate with or symptoms that maybe mapped to pregnancy. But again, the problem I have with this case is there was no clinical evidence of pregnancy in terms of fetal heartbeat monitoring, in terms of ultrasounds, in terms of blood HCG numbers that would show a trend over time, in terms of actual twins that were born, or in terms of clinical evidence of any miscarriage. We're lacking all of that. And so if I were to interview Dr. Medchill, I'd want to know how he ruled out fraud or deception or manipulation as part of his theory of the case. That's kind of what I would want to talk to him about. That could be interesting. We have a fully redacted witness here. Interesting stuff. I wonder what that means. If you have any ideas, let me know. We have other witnesses here that are redacted. It could be an Angel or Angela. Maybe, is this Carmen? Some of the letters they seem to have blocked out. This could be a Matt. That's interesting. Witness Sarah Navarro. That is Laura's sister. And, ladies and gentlemen, Dave Neal, witness for the prosecution. Let's go, guys. Let's go. Do you know what this means? This means Dave is going to be called as a witness, and he's going to have to go up on the stand and testify, and I'm going to have to run StreamYard out of the tech van. I don't know. It's a tough job, but some moose has to do it. Okay, Witness Ron Owens, that's Miss Owens' father. We have another police officer, Detective Maxwell. That's interesting. More officers, Patton, Peckham. We have a witness, Bonnie Platter. Bonnie Platter was one of Laura's original, Miss Owens' original attorneys in this Owens v. Eckerd paternity case. That'll be interesting to hear what she has to say. Let's see. We have another police officer, Plummer. We have a witness. It could be an Anna or an Ann. We have witness Sean Roanhorse. Now, Sean Roanhorse, I believe, is the landscaping contractor or the general contractor and builder that worked on some of the horse buildings on the Owens property and was involved in a legal dispute there. It's interesting that Sean is listed here as a witness. We'll see if he has anything to say about this case when it comes up. We have another fully redacted witness here. That's interesting. Janine, police officer Scott, police officer C. Miller. Okay. This is a huge witness list, guys. This is big stuff. Oh my gosh. This is a lot of witnesses. Now, I was jury foreman on a case here in Washington County, Oregon, and it was a criminal case, and it was about a 2 or 3 day trial. I'm trying to remember if we went to the third day or if we got it all done in 2 days. We probably had a witness list that was the order of 1 or 2 of these pages, I would say, at most. So this is a lot. Okay. We have Officer Silva. We have a witness, Madeline. We have Officer Swan. Witness, looks like it might be Kathy. Witness, Officer Sylvester. We have a custodian of records. That's interesting, for Banner Health. So we're going to get the custodian of records. These are the people who can, for the court, pull information, corporate information, from databases, from devices, from other things that the corporate domain would have in terms of personal information or business information. And then if the court needs it, they can bring it to court. And that has to be brought by a custodian of records. So we've got Banner Health there. That'll be interesting. Witness Jessica, Officer Weege, or Weehay. Witness Andrew from New Jersey. That's interesting. Andrew from New Jersey. Okay, we'll have to see what that's all about. We've got another custodian of records. They don't say where the custodian of records is from. We'll have to see. Witness Greg Woodnick. Of course, this was the lead attorney for Mr. Eckerd in the Owens v. Eckerd paternity case. So that's good. So both lawyers from the June 10th evidentiary hearing are here on the witness list. Mr. Gingras and Mr. Woodnick. Both. And we've got Zeman, witness. Okay, that's interesting as well. Okay, other witnesses. Okay, we've got a bullet list here, 5 bullets. I like how this is organized. It's well organized, guys. They're dotting all the I's, they're crossing all the T's. We've got a bulleted numbered list. Or I should just say a numbered list. I guess they're not really bullets. Anyway, I digress. Any custodian of records for any disclosed item or document. Oh, wow. Maricopa County Sheriff's Office. Okay. MVD. Okay, I don't know who that is. That could be Maricopa something. Banner Hospital, Barrow Dignity Health, Honor Health, Med Spa. Interesting. Mom Doc, Planned Parenthood Los Angeles. Oh boy, we're back in Los Angeles, guys. 1060 OBGYN. Okay, that's interesting. Family Planning Associates, Innova Med Spa, Scottsdale Perinatal Associates. Okay, and that's going to be Higley or McCool probably. SMILE, SMIL, which is Southwest Medical Imaging Labs. Of course, that was where one of the names was changed on a purported sonogram to SMIL, Southwest Medical Imaging Labs. Sonora Quest Labs. Suddenly Slimmer Med Spa. Suddenly Slimmer Med Spa. Oh, dear. Vita Bella Med Spa. There are a lot of spas here, guys. I mean, it's hot in Arizona. Sometimes you got to go to a spa. I understand. Women's Care Phoenix and Social Media. What does that mean? Social media? Like any? Like YouTube and Twitter and Instagram and Facebook and anything? Social media. Guys, prosecution. Can you please tell me, prosecutors, who's Lisa Chen? Okay, I have to take a quick break. I will be right back. All right, ladies and gentlemen, I have returned. I had to talk to my contractor. He was looking for his ladder. And I, the intrepid moose investigator, know exactly where his ladder is. So he's all set. Now, where were we in this other witnesses list in this court document? We are on point 2. Any witness from the defense disclosure. Okay, so we need to see the witnesses that the defense plans to call, if any. Now, of course, the burden of proof is on the state, so they may not call any witnesses. We will have to see. Number 3, any individual named or referred to in the preliminary hearing transcript, grand jury test transcript, police report, or other state's disclosure. Okay, so they're just sort of putting a bounding box around some of these processes and saying if there's an individual we didn't list earlier and they're in one of these documents, we reserve the right to call these witnesses as well. Number 4, cell phone examiner / analyst, cell phone / cell site expert, and computer forensics expert. Okay, so this is a lot of things. Looks like we are going to be getting into computers and cell phones in this case. Number 5, fingerprint technician, forensic document examiner / questionable documents. What? Questionable documents? No. In this case? Come on, guys. Latent print examiner. What are they pulling prints from? The horses? What is happening here? Oh my gosh. Good golly. Did somebody find a baby bump and they got to dust it for prints? Oh my gosh. Would you like to be that technician? We got to dust this baby bump for prints. Oh dear. It's another day at the office, kids. And handwriting expert. Okay, so a handwriting expert. That's going to be interesting. What could that be related to? I wonder. We will have to see. Okay. Rule 15.1 subset B, evidence. The state may introduce into evidence crime / crime scene evidence, pictures, reproductions, PowerPoint presentations. I love a good PowerPoint presentation. Charts or diagrams of the crime. Oh my gosh, diagrams of the crime. Ooh, alleged crime, indictments, crime scene, or any damage or injuries that were a result of the crime. Okay, that's good. Number 2, all physical evidence taken from the defendant. Ooh. And there was probably quite a bit taken back in January with the search warrant execution. Number 3, any fingerprints, footprints, hairs, fibers, blood, bodily fluids. Oh, guys, we're getting real personal now. Chemicals or other forensic evidence found as a result of the investigation of the crime and their analyses. Ooh, interesting. That gives them a lot of leeway. That's a lot of leeway. Number 4, all physical evidence taken as a result of medical exams and the analysis of that evidence. Okay, that's going to be critical for this case because, of course, with the paternity case, we need to see any medical exams related to pregnancy and paternity. Okay. Identification evidence. Number 1, any arrest / booking report or photograph of the defendant related to the charged offenses. Number 2, MVO records. Okay, no, MVD records. Okay, what is MVD? I'm not sure. Is that like a vehicle thing? Prior conviction records. Motor Vehicles Department. Okay, prior conviction records or other records demonstrating a prior identification of the defendant. Number 3, any photographic lineups. Oh my gosh. You never want to be part of a lineup. That's not a good day. Okay, victim evidence. Number 1, photographs of the victim. Number 2, all medical records of the victims if relevant to the crime charged. Okay, that's good. Number 3, all statements made by witnesses for purposes of medical diagnosis or treatment if relevant or applicable. Okay, again, we're dealing with pregnancy and paternity, so medical diagnosis or treatment, maybe even psychological treatment, could be interesting there. Document evidence. Any written instruments, including but not limited to checks, receipts, applications for credit, accounts, or check cashing services. Okay, yeah. Prosecution, can you figure out if this $450,000 from this case was real? And if it was, where is it? That's what I want to know. Number 2, any computer or account access devices, including but not limited to credit cards, debit cards, passwords, account numbers, password generators. Okay, that's good. Passwords, account numbers, and password generators. We need to get to the bottom. Who is Stella/Lisa Chen? Who is Chase J. Jones? Who is Tag? Plus, all of the random, trolling accounts on YouTube, leaving comments on different commentators' channels. Who are those people? I'd like to know. Number 3, any forgery devices, forgery devices, including but not limited to computer software, check blanks, driver's license blanks, social security card blanks, and a laminator. I mean, do they think she's in the casita, like making fake IDs so kids can go to the bar after hours or something? Like, what is happening here? This is probably all boilerplate stuff, guys. I mean, I know I'm just making light of it a little bit, thinking about the laminator. I did pass by the dorm room of a guy back when I was in college who did appear to be making some fake IDs. I don't even know who that guy was. I just sort of dipped out of there real quick. Anyway, it happens. It happens. Let's see, number 4. Samples of handwriting and related analyses. Okay, and we're back to handwriting. I'm not sure there's a lot of handwritten material in this case, but we'll have to see. That's a good thing to think back through this case. Was there anything handwritten that we need to be concerned about? That's interesting. Number 5, bank account records, credit account records, or other receipts or transaction records, including but not limited to transaction records and emails. Number 6, motor vehicle department records, including but not limited to driver's licenses and ID cards. Number 7, vehicle registration and or applications for the same. This all seems very boilerplate. Other evidence. Number 1, any statements of the defendant or of any co-conspirators. Ooh, the conspiracy is ongoing, guys. Mentioned or contained in the police reports or other disclosed materials. Number 2, any writing or recording of the defendant or witnesses. Number 3, any object, representation of an object. A representation of an object. This is very abstract. We're getting into like Renaissance art, the Impressionist era, modern art, maybe. I don't know. This is not Laura Owens, the artist. This is Laura Owens, the podcaster. Okay, anyway, anything or document referred to in the defense disclosure or disclosed by the defense or used or referred to at trial by the defense. So if they mention anything, a thing, an object, it could be evidence. Okay, any grand jury, preliminary hearing, or deposition transcript. Ooh, deposition transcripts. Those could be interesting. Any object, representation of an object, thing, or document referred to in the preliminary hearing. Wait, is this in the preliminary hearing transcript. Okay, grand jury transcript, police report, or in any of the state's disclosures, including but not limited to any evidence arising out of DRs. DR 2024031, Maricopa County Attorney's Office, and any supplements. Ooh, supplements, guys. We could have supplements in this case. I'm excited. Number 6, any video and or audio recording obtained from an officer, an on-officer camera. Okay, so body camera footage, we got it. Any surveillance video. Ooh, surveillance video. That could be interesting. Number 8, the state gives notice that it may introduce FTR recordings of testimony in the case in evidence or use them during closing arguments. Okay, so I think that's, for the record, audio recordings, maybe even, could it be video recordings? Potentially. Okay. Rule 15.1 subset B, notices. Oh, there's a lot of, should we read these? I don't know. Let's see if there's anything interesting in here. I'm reading these notices for the first time. Any other witnesses or evidence will be disclosed seasonably. seasonably. Okay, well, it's summertime. According to Rule 15.6, the state has no obligation to provide witness telephone numbers. Very good. The only witness telephone numbers to be disclosed are those that are already included in police reports or other disclosure materials. Very good. Number 3, all of the listed witnesses' existing relevant written statements have already been provided in the police reports, are provided with this notice, or will be provided seasonably. Seasonably! Get your seasoning. I like that Tony C's seasoning. Anyway, any other statement of a witness that any witness may remember may be obtained through witness interviews. Very good. Number 4, all existing written statements of the defendant have already been provided in the police reports, are provided with this notice, or will be provided seasonably. I'm sensing a pattern. Here, guys. Any other statement of the defendant that any witness may remember may be obtained through witness interviews. Number 5, audio, video, or digitally recorded statements or images are available for review, and copies of such recorded statements or images, if not already provided, will be provided. Oh, I'm sensing a pattern. Will be provided upon request after sufficient arrangements are made, including providing blank tapes. Blank tapes. Do these guys have a stock of cassettes? Because, the vintage audio guys, they like the little 4-track cassette recorders. If they have any blank tapes, I would like to get some blank tapes. Anyway, or compact discs, and paying any reasonable costs associated with making copies. Now, when I worked in the recording studio back in the day, when I was in high school, college, I would make copies of things on cassette, and it was an interesting time, to say the least. Cassettes are not the best, but that was the best we had. Number 6, any exhibit presented to the grand jury has already been disclosed to the defense, except insofar as disclosure may be prohibited by ARS 132812 or any other statute or rule. The state cannot identify for disclosure exhibits that were not admitted or presented to the grand jury. Number 7, defense counsel shall be responsible for recording any witness statements made at an interview of the witness. Okay, so if the defense wants to interview witnesses or take witness statements, they have to record them. Okay, they're responsible for recording them. Number 8, experts to be called as witnesses in this case are listed in the witness list. The names and addresses of experts, along with the completed results of physical examinations, scientific tests for science, experiments, or comparisons have already been provided, are provided with this notice, or will be provided upon completion. Yeah, you can't publish your final report until the experiments are over, right? Number 9, any police officer listed above may be called as an expert witness with respect to an area within the officer's training and experience, including expert knowledge of illegal drugs. Illegal drugs? Do you mean like couriered HCG? Oh my gosh. Their possession or sale, usable amounts, or any other topic. Okay, very good. Number 10, any criminalist, fingerprint analyst, identification technician, or other similar witness will be called as an expert in his or her respective field. Very good. Subset A, all forensic scientists, analyst permits, affidavits, and curricula vitae. That's resume in Latin, guys. Sort of. It's good enough for what we're doing. For Phoenix Police Department Lab Science Bureau are located at this URL. Oh, that's nice. They provide the URL right in the document. B, all forensic scientists, analyst permits, affidavits, and curricula vitae for Scottsdale Police Department Lab Services Bureau are located at, wait, isn't that the same thing? No, we've got Phoenix and Scottsdale. Okay, very good. Number 11, unless otherwise indicated, the state wishes to be present during the interviews of all potential state's witnesses. Okay, that's good. The state's witnesses will be made available for defense interviews except those who testified at a preliminary hearing or juvenile transfer hearing. This is more boilerplate stuff, I think. 12, there was no electronic surveillance. There was a search warrant. Okay, so this is interesting. We did not have, this is news. There was no electronic surveillance in this case, in this investigation. There was a search warrant. Okay, and we've seen the documents related to that. There was no informant whose existence the defendant is entitled to know under Rule 15.4, subset B, subset 2. So, geez. So, they're not saying there's no informant. They're just saying there's no informant whose existence the defendant is entitled to know under this very particular rule. Interesting stuff. There's probably no informants. In any case, number 13, all existing original and supplemental reports prepared by a law enforcement agency in connection with this case have already been provided or are provided with this notice or will be provided seasonably. The seasoning is ongoing, guys. Number 14, the state is unaware of any existing material or information unknown to the defense that would tend to mitigate the defendant's guilt or punishment. Oh no. Yeah, we don't have anything that will exonerate your client. Sorry. Pursuant to, what is this? Oh, there's a case citation, a big long case citation. The state will review any evidence in its possession, determine if any of it is exculpatory, and if so, turn such evidence over to the defense. Yeah, proper discovery. Thank you. Very good. Okay, Rule 15.1, subset D, prior felony convictions. The state intends to use at trial any prior felony convictions of the defendant or defense witness for impeachment purposes pursuant to Rule 609, Arizona Rules of Evidence. Furthermore, the state intends to use defendant's prior felony convictions as aggravating circumstances pursuant to 13701. You know, I don't know that there are any prior felony convictions for the defendant in this case, so this may just be boilerplate type of stuff in terms of, that would just aggravate maybe the circumstances here. Okay, number 2. If applicable, the state has provided or will be providing a list of the defendant's prior felony convictions in a separate allegation. Okay, that's fine. So I don't think there are any of those, but if there are, they will provide them. Number 3, the state will provide a list of prior felony convictions of witnesses the state intends to impeach or call at trial 30 days before trial or 30 days after a request. Okay, that's nice. Now, does that include weekends? It's probably 30 court days, so maybe not. Maybe you can't include weekends. You just have to do weekdays and avoid holidays as well. So that's even more time. That's good. The state cannot provide a list of felony convictions for defense witnesses without an accurate name, date of birth, and social security number for each defense witness. Social security numbers. Mysterious. Number 4, the following witnesses may be called and the following exhibits may be used to prove any prior convictions. Okay, and I think this is just more boilerplate. But we've got all the standard stuff here for a criminal court case, right? Fingerprint technicians, the fingerprints, court filings on priors, custodians of original court files, defendants, defense attorney on the priors, arresting officers on priors, any past or present adult probation officers or parole officers. I mean, this list just goes on and on. Any probation parole files of the prior, any booking photographs, prior fingerprints, certified copies. Certified copies of what? Convictions? Okay, probably. Let's see. Any pen packs from a state federal penitentiary. Pen packs from the federal prison? Oh boy. This is all perfunctory stuff, I think. I think we've run out of the interesting things in this document. In any case, let's see. Let's skip to the next section here. Other evidence upon request. The state will make recordings of existing 911 calls available to defense after a written request by providing an authorization form to be presented to the appropriate custodian of record. Okay, that could be important here. We know there were police calls, whether they were to the non-emergency line or the 911 line. Examination notes made by experts listed in Rule 15.1. Okay, shall be provided within 30 days. All requests to examine or scientifically test items of evidence must be in writing. Very good. Evidence of other acts. Pursuant to Rule 404B, Arizona Rule of Evidence, the state intends to use evidence of other crime, wrongs, or acts to prove motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake or accident, or for any other relevant purpose, and for impeachment purposes that is not otherwise contained in the police reports. It is the state's position that any acts mentioned in the police reports are intrinsic to the charged crimes. That's interesting. And evidence of such are admissible separate and apart from the provisions in Rule 404B. If matters contained in the police reports are deemed evidence of other crimes, wrongs, or act, the state gives notice that it may use such evidence pursuant to Rule 404B. The state will provide notice of specific acts not contained in the police reports and the witnesses it intends to call a trial in separate notice. And you'll see this Rule 404. We heard about Rule 404 in the Lori Vallow Daybell case a little bit. It may not be the same subset, but again, these are rules of evidence, rules of discovery, rules of disclosure. What can you show at trial versus what can you not show at trial if it hasn't been admitted by the judge or part of the discovery? So we're seeing that here in this case as well. State's request for disclosure. Okay, so this is what the state wants. The state requests a list of all papers, documents, photographs, and other tangible objects that the defendant intends to use at trial. Very good. The state requests any completed written reports, statements, and examination notes made by experts the defense intends to call at trial. All right, so we have their evidence and their experts. Number 3, the state requests copies of any recorded statements made during interviews conducted without the presence of a deputy county attorney. Okay, so if they go record statements, do some interviews, and a deputy county attorney is not there, they would like a copy of that. The state requests, pursuant to Rule 15.2, that the defendant submit to being fingerprinted, palm printed, footprinted, photographed, or permit the taking of samples of his or her hair, blood, or saliva at any scheduled court hearing. Submitted June 25th, 2025. Oh my goodness. Rachel H. Mitchell, Maricopa County Attorney. And then it has signature Edward Leiter, Deputy County Attorney. Okay. And of course, the copy here was emailed to the judge, Garfinkel Sandra Schutz, who I believe is part of the counsel for the defendant in Phoenix, Arizona. Attorney for defendant. Okay, I got that right. Very good. That's it, guys. That's what we got. Exciting stuff. Again, we have a huge... I'm kind of blown away by the size of the intended witness list. Now, they may not call all of these people, but they want to be prepared to call these people if they need to. Still, I think this is a very big list. I think it's a good list. It's very comprehensive. It means the investigators, they focused on breadth as well as depth in these indictments. They went through a very rigorous process with these 7 indictments. They went through a grand jury. You don't always have to do that, but it's a good way to dot all your I's and cross all your T's, so you have a good indictment going here. And we have a big list. We've got our boy Dave Neal is on the witness list. That's amazing stuff, guys. Amazing. So that's our news for today. I need to go do a showing at my house later, so I got to get out of here. Cool the van down. The AC's going. Sorry for the noise. If you've stuck around this long, this has been the state's notice of disclosure and request for disclosure in the state of Arizona versus Miss Owens court criminal case. I am Bruce from Oregon, Bruce the Moose, in the tech van. Have a good one.